Welcome to another deep dive. This time we're going to try to demystify South African business law.
Sounds pretty challenging.
Yeah, well, we've got a pretty hefty study guide here. So
Okay.
our goal is to break down those key concepts and hopefully leave you feeling like you've got a solid handle on this complex area of law.
It's almost like having a cheat sheet to the legal playbook for South African businesses.
Exactly.
So we'll be looking at different business structures, exploring roles and responsibilities of everyone involved, and hopefully uncacking those haha moments that can help you make smarter decisions. Whether you're an entrepreneur, an investor, or just curious, this deep dive's for you.
So Study Unit 1 is all about laying the groundwork, understanding the bigger picture of how this area of the law functions in South Africa.
It kicks off by exploring the historical development of South African law, showing how Roman Dutch law, English law, and even indigenous African customary law all contribute to the unique system we have today.
Yeah, it's fascinating to see how all those different legal traditions have shaped the system we have now. What really jumped out at you in this section?
Well, the study guide really emphasizes the impact of the Constitution on business law, and it shows that it's not just an abstract document, but it actually weaves into how businesses function.
So the Constitution isn't just about, like, politics and rights.
Right.
It actually has a direct impact on how businesses are run on a day-to-day basis.
Absolutely. For example, it guarantees fundamental rights like equality and freedom of trade. These are essential for a fair and competitive environment.
Right, so it levels the playing field for everyone.
Exactly. And it goes further by placing obligations on businesses to actually respect human rights and promote social justice. A reminder that businesses are part of a larger societal context.
So it's not just about maximizing profits, it's about ensuring that businesses actually conduct themselves ethically.
Yes.
And contribute to the well-being of society.
Precisely. And they bring up the concept of Ubuntu.
Yeah.
Ubuntu, that idea of humanity and interconnectedness, and how it's becoming increasingly important.
Okay.
It's a value system that emphasizes ethical conduct, fairness, and community, which are all pretty relevant to how businesses operate.
Yeah, I could see how that resonates in a country with such a diverse and complex social fabric. So we've got this foundation of the Constitution, and we've got this concept of Ubuntu. What else should we be taking away from Study Unit 1?
Well, this unit dives into the sources of South African law, so legislation, case law, common law, customary law.
Okay, so we know legislation, that's basically laws passed by Parliament.
Right.
But what about case law? How is that relevant to this?
You know, case law is incredibly important. It shows how those legal principles we just discussed are applied in real-world situations.
Okay.
It's like seeing the law come alive. And it's especially relevant in South Africa, where the legal system relies heavily on precedent.
So judges are looking at past rulings to guide their decisions in current cases.
Exactly. It ensures consistency and predictability in how the law is actually applied.
Okay.
And this study guide highlights how crucial it is to analyze case law to understand the nuances of these legal concepts.
So you can't just learn the rules. You need to actually understand how they've been interpreted and applied in reality.
Absolutely. The study guide provides examples of landmark cases. One that stood out is the Everfresh Market, Virginia, AT Ltd v. ShopRite Checkers, Ltd case.
Okay.
You know, that case really cemented the importance of good faith in business dealings.
Okay.
It involved a long-standing agreement between these two companies. And when one decided to terminate the agreement, the other argued that it wasn't done fairly or transparently.
So I wasn't just whether they could end it, but how they ended it.
Exactly.
Okay.
It was a pivotal case that emphasized the importance of ethical conduct, even in purely commercial relationships.
I can see how that illustrates how the concept of Ubuntu might influence legal decisions.
Absolutely.
What about common law and customary law?
So common law is essentially the body of legal principles developed over centuries through court decisions.
So like the unwritten rules?
Yeah, you could say that. It's the bedrock of the legal system.
Okay.
Customary law refers to the traditional legal systems of indigenous communities.
Right.
It's recognized in the Constitution as a source of law.
Okay.
And it plays a role in certain areas, especially land rights and family matters.
So recognizing the diversity of legal traditions in the country.
Exactly. The study guide stresses that understanding this interplay between all these different sources, legislation, case law, common law, customary law, is absolutely essential for navigating the South African legal system.
Okay, so we've got this rich tapestry of legal sources. all kind of intertwined with the values of the Constitution and the concept of Ubuntu. So South African business law is quite a dynamic and evolving field.
Absolutely. And this study guide highlights how globalization is also shaping the legal landscape, creating both opportunities and challenges.
Right. In today's world, businesses can't just operate in a vacuum, right?
Exactly.
They have to be aware of international laws and trends.
Precisely. And South African law has to adapt to the realities of globalization, for example, by participating in international treaties and agreements.
So finding a balance between upholding local values and participating in the global marketplace.
Absolutely. And you'll see this theme running throughout the study guide.
Got it.
It's about understanding the interplay between legal principles, societal values, and the practicalities of doing business in a globalized world.
That's a great overview of Study Unit 1.
Yeah.
It's really helpful to set the scene for understanding the specifics of different business structures and legal concepts.
It's like we laid the foundation for our legal skyscraper, and now we can get into building the different floors.
I like that analogy. All right, let's move on to Study Unit 2, which focuses on one of the most common business structures in South Africa. Companies.
All right, this unit gets into the nitty-gritty of how companies function from a legal perspective. It starts by explaining this concept of legal personality, which is really a cornerstone of company law.
Can you remind me again why legal personality is so important?
Yeah, so legal personality essentially means that a company is considered a separate legal entity, distinct from its shareholders.
So it's like the company itself becomes a person.
Exactly.
In the eyes of the law.
Yes, it can own property, enter contracts, sue, and be sued, all under its own name.
Okay, and why is that separation so important?
Well, that's what allows for limited liability. The company's debts and obligations are separate from those of its shareholders. So if the company faces bankruptcy, the shareholders' personal assets are generally protected.
That's the benefit, right? It minimizes the risk for shareholders.
Yes.
But you mentioned something called lifting the corporate veil last time we spoke. What's that all about?
Yeah, that's what it gets interesting. Lifting the corporate veil is a legal maneuver that allows courts to disregard that separate legal personality and hold individuals within the company personally accountable.
So it's like saying, we can see through your disguise.
Precisely. And it's usually invoked in cases of fraud. Or reckless trading, or if a company is being used as a front to hide personal wrongdoings.
Okay, so it's a safeguard against abuse of the corporate structure.
Absolutely. The study guide also points to the Companies Act and Close Corporations Act that specifically deal with this.
All right, so we've got this principle of legal personality, but with the understanding that the veil can be lifted in certain situations.
Exactly.
What else should we know about companies from this study unit?
It goes on to break down the different types of companies. So, you've got public companies, private companies, state-owned companies, nonprofit companies.
All right, let's start with the basics. What's the main difference between a public company and a private company?
A public company can offer shares to the public. Anyone can buy them, and their shares are often traded on stock exchanges.
So those are the big companies we see on the stock market, like mining companies, banks.
Exactly.
That sort of thing.
Whereas private companies have restrictions on who can buy their shares. It's usually a limited group of investors.
Okay, so it's about keeping ownership within a specific circle.
Yes, and there are also differences in disclosure requirements. And corporate governance. Public companies are subject to stricter regulations because they answer to a wider range of stakeholders.
Makes sense. Now, what about state-owned companies? How are they different?
Well, state-owned companies are owned and controlled by the government. They often provide essential services like electricity or transport.
Okay, so their mandate is more about serving the public good than just making a profit.
Exactly. They have a very specific legal framework governing their operations.
And lastly, nonprofit companies, or NPCs.
Yeah, NPCs are formed for charitable or public benefit purposes, so not for generating profit for their members.
So their focus is on social good.
Exactly. They're often involved in things like community development, education, environmental protection.
Makes sense.
And they're subject to legal requirements to ensure their transparency.
Yeah, that's important. It's important to have a clear legal framework for organizations that handle public funds or are pursuing charitable missions.
Absolutely.
Okay, so we've got a basic understanding of the different types of companies. What else is there to know about how companies operate?
The study guide delves into the formation of a company. outlines the steps involved in registering the company,
Okay.
the key documents required, and the memorandum of incorporation.
Right, the company's constitution.
Exactly. It sets out the company's name, its purpose, share structure,
Mm-hmm.
the rules governing its internal affairs.
It's a pretty important document.
It is. And the study guide really stresses how important it is to draft this document properly.
Okay.
So it complies with all the legal requirements, and they go into quite some detail about the alterable provisions in the memorandum of incorporation.
Right.
This flexibility allows companies to tailor how they operate.
Now, what about agreements that are made before the company's actually formed?
Ah, good question. Those are called pre-incorporation contracts.
Right.
Those can be a little tricky.
Okay.
So the study guide highlights the statutory method and common law approaches to these contracts and weighs the risks and benefits.
Okay, so it's important to make sure those pre-incorporation contracts are legally binding and enforceable
Precisely.
From the start.
And they provide a really helpful breakdown of the requirements and potential pitfalls.
Right, so we've got the formation side, those pre-incorporation contracts.
Yes.
What else should we know?
Well, they go into detail about company names.
Okay.
Choosing a name, the process for reserving a name, and the potential legal issues that can arise if there are conflicts.
You can't just call your company whatever you want.
Right, exactly.
There must be rules to prevent confusion and protect trademarks.
Absolutely. The study guide provides a clear explanation of the criteria for those names and how you reserve a name with the Companies and Intellectual Property Commission.
Got it.
They even used an interesting case, Peregrine Group, Ltd. and Others v. Peregrine Holdings, Ltd. and Others, which shows how things can get a little messy when companies have very similar names.
Yeah, it's a good reminder that even choosing a name can have legal implications. All right, so we've covered formation, pre-incorporation contracts, company names. What else do we need to know about how companies actually function?
Well, the study guide delves into company capacity and representation.
Okay.
This essentially means what actions a company can legally take, and who's authorized to act on its behalf.
So understanding the limits of the company's power and who makes decisions.
Exactly. The Companies S has broadened the concept of company capacity.
Right.
It's no longer limited by those specific objectives stated in its memorandum of incorporation.
Interesting. So it's a more modern approach that reflects the fluid nature of business today.
Precisely. And it introduces the Turquoise rule.
The what rule?
The Turquoise rule, which protects outsiders who are dealing with the company in good faith, but even if the company's internal procedures haven't been perfectly followed.
Can you give an example of that?
Let's say you enter a contract with someone who seems to be a director of a company. You have no reason to believe they're not authorized. But later you find out, oh, they actually overstepped their authority. The Turquoise rule might still bind the company to that contract.
So it protects the person dealing with the company, even if there are internal problems.
Yes, it's about fairness and preventing companies from using internal issues to get out of their obligations.
Okay, that's an important point for anyone who's doing business with a company.
And they link the Turquoise rule to the doctrine of estoppel, which is this legal principle that prevents a party from going back on a statement if someone relied on it to their detriment.
Got it.
So if a company creates an impression that someone has authority, they can't deny it later if a third party relied on that.
So actions speak louder than words?
Exactly.
And companies need to be held accountable.
Absolutely.
Okay, this has been really helpful.
Yeah.
It's amazing how much depth there is to this topic.
Absolutely. And we've just scratched the surface of Study Unit 2.
Yeah.
There's a lot more to unpack, like shares, finances, and the roles and responsibilities of those shareholders and directors.
I'm ready to delve deeper into those topics.
Awesome. Let's continue our exploration into South African company law. Welcome back to our deep dive into the intricate world of South African business law. Last time, we laid the groundwork, exploring the historical context, the impact of the Constitution, those different sources of law, and we even started to unpack this idea of companies.
Yeah, it was fascinating to get that behind-the-scenes look at how legal principles shape how businesses actually operate. But there's still a lot to uncover.
Absolutely. And in this part, we're going to delve even deeper into those inner workings of companies. We're still on Study Unit 2 of this pretty comprehensive study guide, so we're going to pick up where we left off with shares and finances. Okay,
shares, those little pieces of ownership everyone's always talking about. What are they and why are they so important?
Well, at their core, shares represent ownership in a company. So when you buy a share, You're buying a slice of the company's assets and future earnings. Think of it like owning a piece of the pie.
Makes sense. But I remember there are different types of shares, right? What's the difference between those?
You're right, not all shares are created equal. The study guide breaks down those different classes of shares, explaining that each one comes with its own set of rights and privileges. We've got preference shares, ordinary shares, and even something called deferred shares.
Okay, preference shares, what makes them special?
Well, preference shareholders get preferential treatment when it comes to dividends. So those payments a company makes to its shareholders from its profits, they get paid before the ordinary shareholders. And if the company is wound up, which means closing down, they also get priority in getting their investment back.
So it's like they've got a higher priority claim
Exactly.
on the company's asset.
Exactly. But there's a trade-off. Often, in return for that preference, they might have limited or even no voting rights.
Okay.
So less say in how the company's actually run.
Interesting. So with preference shares, you prioritize the financial return
Yes.
over control. What about ordinary shares? Those seem more like the typical shares that people talk about.
They're the most common type. Ordinary shareholders usually have full voting rights, giving them a say in, electing directors,
Okay.
making big decisions about the company's future.
So you have more of a voice.
Exactly.
What about those deferred shares? They sound intriguing.
Yeah, deferred shares are a bit more unique. They don't get any dividends until all the other shareholders have been paid, and even then, only if the profits exceed a certain level.
So a bit riskier.
They can be, but also have potential for higher rewards. It's like betting on the company's long-term success.
Okay.
They're often used to incentivize key employees or founders,
Yeah.
giving them a bigger piece of the pie if the company really takes off.
That's a smart strategy. Aligns their interest with the company's growth.
Right.
The study guide also mentions something called preemption rights, particularly in private companies. What are those all about?
Preemption rights are important for protecting existing shareholders. Imagine you own a chunk of a company, then the company decides to issue more shares.
Right.
Suddenly, your ownership stake is diluted.
It's worth less.
Exactly, because there are more shares out there.
So even though the pie might be getting bigger, my slice is getting smaller.
Exactly. Preemption rights give those existing shareholders first dibs.
On buying those new shares, in proportion to what they already own.
Okay.
So they can maintain their ownership percentage even when new shares are issued.
So it stops them from getting squeezed out.
Exactly.
It's a valuable protection. Okay, we've covered shares, different types, those preemption rights. What about the financial side of things? How do companies manage their money?
Well, the study guide goes into financial distributions.
Okay.
This is when a company decides to pay out profits to those shareholders. It's a big deal, impacting both the company's stability and the shareholder returns.
Right, like deciding how to slice that profit pie.
Exactly. And there are legal safeguards in place to ensure this is done responsibly. The study guide explains that before making those distributions, a company has to pass something called a solvency and liquidity test.
Okay, what do those tests involve?
They're designed to ensure the company has enough assets to cover its debts, that's the solvency part, and enough liquid assets, like cash, to meet short-term obligations. That's liquidity.
And this is even after making the distributions.
So it stops companies from, paying out dividends when they're actually in financial trouble.
Exactly. It's about responsible financial management, protecting everyone involved.
Makes sense. Now, the study guide also mentioned financial assistance for purchasing company securities. Can you explain that?
So this is when a company provides financial help,
Okay.
like a loan or a guarantee, to someone who wants to buy shares or other securities in the company.
Okay, I can see how that could be useful in some cases.
It can be, but the Companies Act puts strict conditions on this type of assistance
Right.
to prevent abuse.
What kind of abuse?
Well, imagine a company is struggling, but the directors want to stay in control. They might use company funds to help a friendly investor buy up more shares, propping themselves up. That's not in the best interests of the company.
So it's about preventing conflicts of interest, making sure the company's resources are used responsibly.
Exactly. The study guide really emphasizes how important it is to comply with these regulations to avoid legal issues. It even highlights a key case, Lipschitz v. UDC Bank Ltd., which gave some important guidelines for interpreting these rules.
That's helpful. Shows how these things actually play out in real legal situations. Now, what about debentures? How do they differ from shares?
Debentures are essentially loans that a company takes out. Instead of buying a piece of the company, like you do with shares, you're lending the company money.
So you become a creditor.
Exactly. And the study guide points out that debenture holders, they're entitled to regular interest payments, and they have priority over shareholders if the company is liquidated. So it's seen as a less risky investment.
Makes sense. Okay, so we've covered shares, different types, those preemption rights. We talked about financial distributions, financial assistance, debentures. What else should we know?
Well, it gets into the roles and responsibilities of two key players in a company.
Okay.
Shareholders and directors.
All right, let's start with shareholders. They're the owners of the company, right?
Right.
But what does that mean in terms of their rights and powers?
Being a shareholder is more than just holding a certificate. It comes with a set of rights and responsibilities that are essential for a company's operations. The study guide explains that shareholders have the power to elect the company's directors. Those responsible for managing the day-to-day business.
So shareholders have a say in who's steering the ship.
Exactly. They also have the right to approve major decisions, like amending that memorandum of incorporation or even winding up the company.
So they have a voice in the big picture decision.
Precisely. And they have a right to receive those dividends we were talking about. But the study guide emphasizes that they also have responsibilities. Staying informed, exercising their voting rights responsibly. It's not just about receiving those dividends, it's about actually participating.
It's active ownership.
Exactly.
All right, let's talk about the directors. They're the ones actually running the show.
Yes.
What is their key responsibilities?
Directors have a lot on their plate. The study guide really unpacking their duties, emphasizing both their legal obligations and the ethical considerations that should guide their actions. So it's about understanding that their primary duty is to act in the best interests of the company.
So it's not just about making money. It's about making decisions that benefit the company as a whole?
Exactly. And that includes all stakeholders, not just the shareholders.
Okay.
Thinking about the impact of their decisions on employees, the community, even the environment.
That's a huge responsibility. What are some of those specific duties they have to fulfill?
The study guide breaks down different types of director duties, including fiduciary duties, statutory duties, and common law duties.
Okay, let's start with fiduciary duties.
So fiduciary duties require them to act honestly and in good faith. Avoid those conflicts of interest, disclose any personal interests that might sway their decisions.
Transparency is key.
Absolutely. And then statutory duties are those spelled out in legislation, like the Companies Act. For instance, directors have a duty to exercise care, skill, and diligence in their decision-making.
So they can't just make reckless decisions
Exactly.
that harm the company.
Exactly. And common law duties, those have evolved over time through court decisions, unwritten rules based on principles of fairness and ethical conduct.
Got it.
So, for example, directors have a duty to act for a proper purpose, meaning their decisions should align with the company's objectives, not for personal gain. No hidden agendas.
So ensuring that they're using their power responsibly. Now, the study guide mentioned that a director can be disqualified or removed from their position. What are some grounds for that?
There are several reasons why a director could be disqualified. It could be due to a breach of those fiduciary duties, acting recklessly or fraudulently, or even being declared delinquent.
Delinquent? That sounds serious. What does that mean?
Delinquency covers a range of misconduct, like continuously failing to attend board meetings, being grossly negligent in managing the company's affairs, or using company funds for personal gain.
So it's about holding them accountable, making sure they fulfill those responsibilities.
Exactly. And the study guide details the procedures for declaring a director delinquent. And the potential consequences, which can include being banned from serving as a director for a period of time.
So there are repercussions for bad behavior. Now, what about board committees? What are those and why are they important?
Board committees are like specialized subgroups within the board of directors, focusing on specific areas like auditing, remuneration, which is basically setting executive pay, or social and ethics issues.
So dividing responsibilities, bringing in expertise in key areas.
Exactly. Allows the board to delegate tasks and ensure those functions are handled well. For example, the study guide highlights the role of audit committees in ensuring the accuracy and integrity of the company's financial reports.
So it's a multi-layered approach to accountability. Now, let's talk about the legal recourse available to shareholders and companies if their rights or interests are violated. What options do they have?
The study guide outlines a range of remedies and enforcement mechanisms under South African law. It emphasizes that it's crucial to understand these options to effectively protect your rights in a business context.
So it's like knowing what tools you have in your legal toolbox.
Precisely. The study guide, for example, explains the concept of a declaratory order, which clarifies the rights and obligations of parties in a dispute.
So it's like asking the court to say, hey, what are my rights in this situation?
Exactly. It provides legal certainty, and it also discusses the statutory derivative action, which allows certain individuals to sue on behalf of the company if its interests are being harmed.
So it's like a way for shareholders or other stakeholders to step in and protect the company if the leadership is not doing so.
Exactly. It's a way to hold directors accountable and prevent those in power from abusing that position.
It's an important safeguard. What other remedies are available to shareholders?
Well, they highlight Section 163 of the Companies Act,
Okay.
which offers relief from oppressive or prejudicial conduct. This is about protecting shareholders, especially minority shareholders, from being treated unfairly.
Can you give me an example of what that might look like?
Sure, imagine a majority shareholder is making decisions that benefit themselves at the expense of the minority shareholders,
Okay.
or excluding the minority shareholders from key decisions or denying them access to information. Those actions could be considered oppressive or prejudicial, and those shareholders could seek relief under Section 163.
So it's a way to ensure fairness and prevent the majority from kind of steamrolling the minority.
Exactly. It's about protecting the rights of all shareholders.
Okay. Now, the study guide also mentioned appraisal rights. What is those?
Appraisal rights give dissenting shareholders, those who disagree with a particular company action, the right to have their shares bought back by the company at a fair price.
Okay.
It's like an exit strategy for shareholders who don't want to be part of a decision they don't support.
Can you give me an example of when a shareholder might use that?
Sure. Let's say a company's planning a merger that a shareholder thinks is a bad idea.
Mm-hmm.
That shareholder can use those appraisal rights to basically force the company to buy their shares so they can get out before that merger happens.
So it gives them a way to protect their investment if they don't agree with the direction the company's going.
Exactly.
Okay, so we've talked about remedies and enforcement mechanisms. What about alternative dispute resolution? The study guide mentioned that as a way to resolve disputes without going to court. Tell me more about that.
ADR, or alternative dispute resolution, involves processes like mediation, conciliation, and arbitration. These aim to help parties resolve disputes outside of the formal court system.
So it's a more collaborative, less adversarial approach.
Exactly. It can be faster, cheaper, and less stressful than going through the courts. The study guide explains the benefits of ADR and the different methods available.
Okay, can you briefly explain those methods?
Sure. In mediation, you have a neutral third party helping the party communicate to reach a solution. Conciliation is similar, but that third party might take a more active role in proposing solutions. Then you have arbitration, which is more formal. The parties present their case to an arbitrator who makes a binding decision.
So there's a range of options depending on the nature of the dispute.
Exactly.
Okay, we've covered a lot of ground on companies, their formation, finances, roles of shareholders and directors, remedies, and enforcement mechanisms. What's next?
So now that we have a solid understanding of companies, we're going to move on to other business structures. Study Unit 3 dives into trusts. Trusts are versatile tools used for various purposes, from asset protection to estate planning.
Okay, trusts, they're always a bit of a mystery to me. How do they actually work?
A trust is a legal relationship where one person, called the founder, transfers assets to another person, the trustee, to hold and manage for the benefit of someone else, the beneficiary. So you're creating a separate entity to safeguard and manage assets for a specific purpose.
So separating the ownership and control of assets.
Exactly. The trustee has a fiduciary duty to act in the best interests of those beneficiaries.
Okay.
And this is outlined in a legal document called the trust deed.
Okay.
It's like a set of instructions for how the trust should be managed.
Makes sense. Now, why would someone set up a trust in the first place?
Well, the study guide highlights a few advantages. Asset protection, for one, because the assets are legally owned by the trust, not the founder or the beneficiary.
Okay.
They're generally protected from creditors.
It's like a shield around those assets.
You could say that. Another advantage is estate duty savings. Because the assets are held in the trust, they're not part of the founder's estate when they die.
Okay.
Which can reduce estate taxes.
Right, so a way to minimize taxes and pass on those assets more efficiently.
Exactly.
What else should we know about trusts from this unit?
Well, they explain different types of trusts, like discretionary trusts, where the trustee has discretion over distribution, and fixed trusts, where those beneficiaries and entitlements are clearly defined.
So some flexibility.
Yes.
In how trusts can be structured.
Exactly. And they highlight the legal requirements for actually creating a trust. You need a valid trust deed, a trustee, and you have to lodge that trust deed with the master of the high court.
It sounds like setting up a trust is a fairly complex process. Probably a good idea to get some professional advice.
Absolutely. They're powerful tools, but they need to be set up and managed correctly.
Okay, so we've covered companies and trusts. What other business structures does the study guide explore?
Study Unit 4 dives into partnerships.
Okay, partnerships. Those seem pretty straightforward. Two or more people team up, share profits, losses. What else is there?
It sounds simple, but there are some specific legal principles that govern how partnerships actually work. One key difference is that partnerships don't have separate legal personality, unlike companies or close corporations.
Remind me again what separate legal personality means?
It means that the partnership isn't considered a separate entity from the partners.
Right.
So the partners are personally liable for the partnership's debts.
So it's a higher risk structure.
It can be. Creditors can go after those partners' personal assets.
Okay.
That's something to consider.
Important to keep in mind. What else is important to understand about partnerships?
Well, they go into those essential elements: contribution, joint benefit, profit sharing. Each partner contributes something, whether it's capital, skills, labor. It has to be operated for their joint benefit, and they have to agree to share profits.
Pooling resources, working together.
Exactly, and they emphasize the importance of a partnership agreement, outlining the rights and obligations of each partner. It's like a roadmap setting out how decisions are made, how profits are shared, and how the partnership can be devolved.
Prevents misunderstandings down the line. Now, what about that principle of mutual mandates? Does that apply to partnerships?
It does. In a partnership, each partner can bind the partnership to contracts,
Okay.
as long as it's within the scope of the partnership's business.
So if one partner makes a deal, all the partners are bound by it.
Yes. It highlights the importance of choosing your partners carefully and having that clear understanding.
A lot of trust involved.
Absolutely.
The study guide also provides some examples of how this plays out in real-life situations. Okay, so we've talked about companies, we've talked about trusts, partnerships. Is there one more business structure?
Yes, the last one is close corporations, or CCs. These were designed to provide a simpler alternative to companies, especially for smaller businesses.
All right, CCs. What are the key things to understand about them?
Well, like companies, CCs have separate legal personality. They're treated as distinct legal entities, separate from their members.
So the members have limited liability.
Generally, yes, their personal assets are protected, but remember that piercing the corporate veil concept we talked about
Right.
applies to CCs too.
Okay, so it's not a foolproof shield.
Right.
What else is unique about close corporations?
They're formed through a founding statement, which is simpler than a company's memorandum of incorporation.
Okay.
It outlines the basic details of the CC, the contributions of each member.
And is that a public document, like a memorandum of incorporation?
It is. It's registered with the CIPC and available for public inspection.
Okay.
So transparency is important.
Got it. What about ownership in a CC? How does that work?
That's another interesting difference. In a CC, members have interests expressed as percentages rather than shares. So instead of owning a certain number of shares, you own a percentage of the CC.
It's a different way of slicing the pie.
Exactly. The study guide explains how those members' interests can be acquired and transferred, outlines that right of preemption for existing members, and points out the implications if a member's interest is attached and sold in execution.
Okay, that sounds complicated. What does that mean?
Imagine a member has unpaid debts. A creditor could get a court order to attach and sell that member's interest in the CC to recover the debt.
So it's a way to ensure creditors have some recourse.
Exactly. Now, when it comes to the duties and responsibilities of members in a CC, they have similar obligations to directors in a company. They owe a fiduciary duty to the CC, meaning they must act in good faith and in its best interest.
So same principle, putting the entity's needs first.
Exactly. They also owe a duty of care and skill. They have to act reasonably and diligently.
Okay.
The study guide provides some examples of how these duties play out, the consequences of breaches, the remedies available, and it even highlights the statutory derivative action, which, you remember, allows a member to sue another member on behalf of the CC if there's been a breach of duty.
So CCs offer a simpler structure, but they still have safeguards in place.
Exactly. They're a popular choice for smaller businesses here, and understanding their legal framework is really important.
This has been an incredibly informative deep dive. We've covered so much, from those foundational principles to the nuances of companies, trusts, partnerships, and even close corporations.
It's been a comprehensive journey. We've really explored the rights and responsibilities of everyone involved: shareholders, directors, trustees, partners.
And we've seen how that legal framework's always changing, keeping pace with the business world, incorporating concepts like Ubuntu, corporate social responsibility.
It's dynamic, it's fascinating, and I hope this deep dive has equipped you with the knowledge to navigate this world with confidence.
Welcome back. We've covered so much ground already, from the basics of the Constitution and Ubuntu to the ins and outs of companies, trusts, and even partnerships.
It's been quite a journey through this study guide.
It has. Now we're on the final stretch, looking at the last bits of Study Unit 5, which focuses on some really practical stuff like enforcement. And it kicks off with this concept of business rescue.
Yeah, business rescue is a pretty interesting development in South African law. It's all about trying to help companies that are in financial distress.
Okay.
Give them a fighting chance to restructure and avoid liquidation.
So it's like throwing a lifeline to struggling businesses.
Exactly. The study guide really emphasizes that. It's about maximizing the chances of a company surviving, which ultimately benefits everyone, employees, creditors, and the economy as a whole.
Right. So how does this rescue process actually work?
Well, it's a formal process. It involves appointing a business rescue practitioner who steps in and takes over the management of the company.
Okay.
They essentially develop a plan to try and rescue the business.
So bringing in the specialists to try and turn things around.
Exactly. And they have pretty broad powers, to restructure the company's affairs, negotiate with creditors, even sell off assets if they need to.
I imagine that could be quite intense for everyone involved.
It can be. But again, the goal is to find a solution that lets the company keep operating.
Now, the study guide also mentioned something called compromise. It sounds like, is it like a negotiation?
Yeah, compromise and arrangement is essentially a way for a company to propose a compromise to its creditors.
Okay.
Maybe restructure some debt, even try to reduce the amount owed. It's about avoiding those drawn-out legal battles.
Right, so trying to find an amicable solution.
Exactly. It's a formal process. There's a proposal, a vote, and if the creditors accept, it needs court approval.
Okay, so it's all very transparent and structured.
Right.
Now, the study guide also mentions something called winding up, which sounds a bit final. Is that right?
Yeah, winding up is basically the process of dissolving a company.
Okay.
Bringing its existence to an end.
Right.
And it can happen in two ways.
Okay.
Voluntary winding up is where the shareholders decide to close it down, or compulsory, where a court orders it.
Okay, so different ways a company can reach the end of the road. What are some common reasons for a company to be wound up?
Well, as we touched on earlier, financial distress is a big one. If a company is insolvent, the creditors can apply to have it wound up. But it could also be, the company has fulfilled its purpose. Maybe there are shareholder disputes that just can't be resolved, or even illegal activities.
So it's like the final chapter in the company's story.
It is. And the study guide goes through the whole winding up process. A liquidator is appointed to gather assets, pay off debts, and whatever's left is distributed to the shareholders.
That sounds like a pretty involved process.
It is. There are a lot of legal considerations, and the study guide stresses the importance of getting professional advice if you're ever in that situation.
Yeah, makes sense. Okay, so we've talked about business rescue, compromise, winding up. That pretty much covers the life cycle of a company. What's the last topic?
The final chapter is all about corporate governance, those principles and practices that make sure companies are run ethically, responsibly, and in everyone's best interests.
We've talked about that a lot throughout this deep dive.
It's a recurring theme, and for good reason. It's become so important, especially with all the corporate scandals we see. There's this increasing demand for transparency and accountability. The study guide makes it clear good corporate governance goes way beyond just following the law.
Right.
It's about creating a culture of ethical behavior.
So it's about going above and beyond, really taking those principles of fairness and transparency to heart.
Exactly. The study guide points to the King IV report on corporate governance, which, while not a law itself, it's full of really helpful guidelines and best practices for South African businesses.
Okay.
It covers everything from board composition to risk management.
Wow, it sounds pretty comprehensive.
It is. It's a great resource for any business leader who wants to run their company ethically and effectively.
This has been a fantastic deep dive. I feel like we've really gained a solid grasp of how businesses work and the laws that affect them.
Absolutely. The more we know, the better decisions we can make, whether we're starting a business, investing in one, or just trying to understand the world around us.
Thanks for joining us. We'll see you next time for another deep dive.
Yeah.